I said it. I said he had to go. After further thinking about it, bruh, I said Glanville had to go. And the way that they got him, A+ around the board. Let's go. Let's start the show. Order on motions to recuse Judge Glanville. This case is before the court to consider various motions to recuse, including Defendant DeMonte Kendrick's motion to recuse Chief Judge Earl Glanville, filed on June 12, 2024. Kendrick, Caleb Bumpus' motion to quash the show cause order and/order to recuse Judge Glanville. Defendant Jeffrey Williams' motion to disqualify recuse Judge Glanville from all further dealings in the above referenced case and amended supplement. The specific facts necessary to determine these recusal motions are well documented in affidavits, court filings, certified transcripts, and video recordings available on YouTube. Having considered the record evidence and applicable case law, the court finds as follows. Findings of fact. These recusal motions arise out of a multi-defendant prosecution brought by the Fulton County District Attorney Office alleging gang activity and associated crimes. Although there were 28 defendants named in the indictment, only 6 were being tried as of June 7, 2024. The motions to recuse all arise from the same circumstances related to state witness Kenneth Copeland. On June 7, 2024, the state intended to call Kenneth Copeland to testify. Prior to his testimony, counsel for Mr. Copeland, Jonathan Melnick, appeared and indicated in open court that Mr. Copeland did not wish to testify and intended to invoke his Fifth Amendment privilege against self-incrimination. Judge Glanville brought Mr. Copeland into court and discussed with him the effect of an immunity order Judge Glanville had entered the granted immunity to Mr. Copeland. Judge Glanville specifically advised Mr. Copeland that if he invoked the Fifth Amendment and refused to testify, the state would ask for Copeland to be held in contempt and jailed. Judge Glanville also advised that if asked, Judge Glanville would jail Mr. Copeland for refusing to testify. After that discussion, Mr. Copeland spoke to his attorney and then indicated he would testify. Once called, Mr. Copeland was asked to specify his age, and instead of answering, he stated, "I plead the Fifth." Judge Glanville excused the jury and then advised Mr. Copeland in open court that he was in contempt and ordered him jailed until Monday, June 10, 2024, at which time Judge Glanville told Mr. Copeland they would revisit Mr. Copeland's willingness to testify. Mr. Melnick spoke to Mr. Copeland and then reiterated to the court that Mr. Copeland still intended to invoke his Fifth Amendment right if called as a witness. Judge Glanville indicated he would revisit the issue of Mr. Copeland Monday, June 10, 2024 at 8:30 a.m. and court was adjourned for the day. On June 10, 2024 at approximately 9:10 a.m., Judge Glanville met with counsel for the state, Adrian Love, and stand-in counsel for Mr. Copeland, Caleb Bumpus. The meeting took place in Judge Glanville's chambers. Counsel for the trial defendants did not participate in the meeting and were not aware that the meeting was taking place. The transcript reflects that Ms. Love told Judge Glanville that she wanted to meet to both impress upon Mr. Copeland the risk of refusing to testify and allow Mr. Copeland to ask questions before he testified. Ms. Love also expressed concerns to Judge Glanville about Mr. Copeland's representation. Ms. Bumpus, Ms. Love, and Judge Glanville also discussed the scope and effect of the state's grant of immunity to Mr. Copeland. Mr. Copeland was then brought to Judge Glanville's chambers where he spoke with and asked questions of Ms. Bumpus. Judge Glanville and Simone Hilton, counsel for the state, who had joined the meeting. During that time, the state advised Mr. Copeland that he could remain in custody until the conclusion of the trials of all defendants in this case, not just the 6 currently on trial. Judge Glanville discussed OCGA 24-5-507 with Mr. Copeland and his rights and responsibilities after a grant of immunity. Mr. Copeland spoke privately with his stand-in counsel, Ms. Bumpus, and then advised the court that he would testify. After the meeting, and immediately before Mr. Copeland brought out to testify, Defendant Williams' lawyer, Brian Steele, objected to the ex parte meeting, and a lengthy colloquy occurred between Mr. Steele and Judge Glanville, in which Judge Glanville inquired how Mr. Steele became aware of the chamber meetings. Mr. Steele declined to reveal the source of his information. Judge Glanville held him in contempt. Though Mr. Steele was allowed to remain in the courtroom on behalf of his client, Defendant Williams, ultimately, Kenneth Copeland did testify on June 10, 2024, and was later released from custody. The next day, Judge Glanville issued a show cause order requiring everyone present at the ex parte meeting to appear and show cause as to why they should not be held in contempt for disclosing information about the ex parte meeting to defense counsel. An amended show cause order was later entered, setting July 1st, 2024 for an in-camera review of the transcript of the ex parte meeting. The first motion to recuse filed by DeMonte Kendrick on June 12, 2024. Mr. Kendrick's motion seeks to recuse Judge Glanville for his involvement in the allegedly improper and coercive ex parte meeting with the state. On June 14, 2024, Judge Glanville denied the motion. Judge Glanville determined the recusal motion was timely, supported by an affidavit, and on a cursory review contains assertions of fact to support the allegations of bias and partiality. However, Judge Glanville ultimately determined that because there was no way to verify the veracity of the information contained in the affidavit and there was no actual evidence of the extent of the discussion during the in-chambers meeting, the affidavit was legally insufficient and the motion to recuse did not require referral to another judge for consideration. On June 14, 2024, Caleb Bumpus then filed a motion to quash the show cause order and or to recuse Judge Glanville from presiding over any contempt action against Ms. Bumpus resulting from alleged disclosure of the ex parte meeting. On June 17, 2024, Jeffrey Williams filed his motion to recuse Judge Glanville. Divorced from its hyperbole, Mr. Williams' motion and supplement also seek to recuse Judge Glanville because of his involvement in the ex parte meeting, which Mr. Williams also alleges was improper and coercive. Mr. Williams' motion alleges both actual bias and the appearance of bias because Judge Glanville allegedly participated in the accusatory process when he met with Mr. Copeland, and Judge Glanville became embroiled in a controversy when he held Mr. Williams' lawyer, Brian Still, in contempt on July 1st, 2024, the day appointed for the parties to review a redacted transcript of the ex parte meeting. Judge Glanville announced that he was releasing the entirety of the transcript of the ex parte meeting and was taking judicial notice of and making a record regarding certain matters associated with ex parte meeting. Most of what Judge Glanville relayed was a coalition of record evidence about the recent circumstances in the case. Judge Glanville also explained how he became aware of the state's request for an ex parte meeting and addressing the circumstances of the contempt against Mr. Steele. Judge Glanville explained the court's purpose and concern in pursuing information about the security and confidentiality of his chambers. Judge Glanville advised that he had not instigated an investigation into surveillance footage, but had reviewed such footage for timeline and security. Judge Glanville then explained his view that the ex parte meeting was proper under Georgia law and outlined relevant law that supported his inherent authority to hold such a meeting. Judge Glanville maintained that no one gained a tactical advantage as a result of the ex parte nature of the meeting. Judge Glanville also questioned defendants' right to be present at the ex parte meeting because the issue under discussion was between the state and a witness who was represented by counsel. After making this record, Judge Glanville announced that the show cause here was canceled and that the recusal motions filed by Mr. Kendrick, Mr. Williams, and Ms. Bumpus were being referred by consideration by another judge in accordance with Uniform Superior Court Room 25.1 through 25.7. The motions to recuse were then assigned to this court for consideration. Legal framework. Motions to recuse are governed by a specific legal framework outlined in Rule 25 of the Uniform Rules of Superior Court. A party seeking recusal must file a timely motion supported by an affidavit clearly stating the facts and reasons for the belief that bias or prejudice exists. USCR 25.1, 25.2. The affidavit must be definite and specific and describe circumstances of extrajudicial conduct or statements which demonstrate either bias in favor of any adverse party or prejudice toward the moving party in particular, or a systematic pattern of judicial conduct toward persons similarly situated to the moving party, which would influence the judge and impede or prevent impartiality in that section. If the screen just blacked out, my bad, but something's going on with this phone. USCR 25.2, bare conclusions and opinions are not legally sufficient to support the motion or warrant further proceedings. On such a motion is filed, it is the duty of the assigned judge to temporarily cease to act upon the merits of this matter and assess the timelines and legal sufficiency of the affidavit and alleged facts. USCR 25.5, if all three criteria are met, i.e. the motion is timely supported by an affidavit and the facts alleged might warrant recusal, another judge shall be assigned to hear the motion to recuse. When considering a motion to recuse, the assigned judge should be
guided by Rule 2.11 of the Revised Code of Judicial Conduct, which provides that judges shall disqualify themselves in any proceeding on which their impartiality might reasonably be questioned. A&M Hops LLC, I don't even know how to say that. We ain't even finna do that. The standard is objective from the perspective of a reasonable, fair-minded, and impartial person, rather than the affected judge or other interested parties. If a motion to recuse satisfies the 3 threshold criteria, the assigned judge must refer the motion for reassignment and may not oppose the motion. Mundy versus Magnolia advanced mistrial. We ain't finna do all that. The judge whose recusal is sought may not respond to the motion or attempt to refute the allegations, which stand denied automatically, no matter how false or even defamatory the judge might know or perceive the allegations to be. A judge cannot become actively involved in presenting evidence or argument against a motion seeking his recusal without that defense itself becoming a bias for recusal. Damn. That's crazy. Let me reread that for y'all. A judge cannot become actively involved in presenting evidence or argument against a motion seeking his recusal without that defense itself becoming biased for recusal. Meaning, if you try to defend yourself and hire somebody, which Glanville did, he showed up with a lawyer, bro, that's going to show bias from how it's sitting with me. That's how I take that. A judge has no interest in sitting on a particular case. At most, his interest lies in protecting his sworn reputation. His efforts at defending himself against a motion to recuse will inevitably create an appearance of partiality. One reason is that if he defends himself, he becomes an adversary of the movement for recusal. This adversarial posture may create an antipathy I don't know how to say that, which persists after the motion to recuse is denied. That's exactly what I just said. Bruh, just defending yourself on your actions look bad and you gotta go. Analysis and discussion. Here, Judge Glanville had previously announced on the record that the motions were timely and supported by an affidavit, and transferring the cases to another judge for consideration. Judge Glanville necessarily determined that the 3rd criteria was satisfied, i.e. that recusal might be authorized if the facts alleged in the motion were assumed true. Therefore, Judge Glanville was required to refer the motion for reassignment and was prohibited from opposing the motion. It is worth noting that this court agrees generally with Judge Glanville's assessment of the propriety of the ex parte meeting, which means Seti Nash was right. This judge said Seti Nash was right. Judge Glanville said Seti Nash was right. Seti Nash said Judge Glanville was right. Victory lap, baby. Where was I? It is worth noting that this court agrees generally with Judge Glanville's assessment of the propriety of the ex parte meeting. While the meeting could have and perhaps should have taken place in open court, nothing about the fact of the meeting or the substance discussed was inherently improper. However, in his order denying defendant Kendrick's motion and the process of making his record on July 1st, 2024, Judge Glanville added facts, provided context, questioned the veracity of allegations, and otherwise explained his decisions and actions and argued why those actions were proper. While it may have been appropriate for a judge to disclose information relevant to his potential recusal, such a disclosure must be made in a way that is objective, dispassionate, and non-argumentative as possible, so that the judge is not reasonably perceived as a hostile witness or advocate. In presenting his record as to the recusal issues and in ruling on Kendrick's motion, Judge Glanville evaluated and accepted the truth of his own factual allegations, mandating his recusal. The court has no doubt that Judge Glanville can and will continue presiding fairly over this matter if the recusal motions were denied, but the necessity of preserving the public's confidence in the judicial system weighs in favor of excusing Judge Glanville from further handling this case. Based on foregoing, this court hereby order as followed: defendant DeMonte Kendrick's motion to recuse Chief Judge Glanville is granted. Caleb Bumpus' motion to quash and show cause and to recuse Judge Glanville is denied. Whoa. Defendant Jeffrey Williams' motion to disqualify recusal Judge Glanville from all further dealings in the above referenced case as amended and supplemented is granted. The clerk shall reassign this case using the court's case assignments procedures. It is so ordered this 15th day of July 2024. The Honorable Rachel Krause, Fulton County Superior Court, Atlanta Judicial Circuit.
Hey, yo, you. Can you subscribe and turn on that bell too? Because when you do, you're helping unbiased independent news. After reading what I wrote, I'm going to say this. Even though technically I was right, I was wrong about how I went about it. And understanding where y'all was coming from, I get it. Let me give you a little history about Seti Nash, right? When I was a youngin' at like 5 years old, I wanted to be a lawyer. True story. My grandma, my father's mother, basically told me all lawyers were liars and stuff like that, so I didn't want to be one. And I started gangbanging at 9 years old, like a couple years after that. But what ended up happening was I started becoming immersed in Perry Mason and Boston Legal and all of these freaking just these lawyer dramas and stuff like that. What's the song? I don't remember. Jim Rockford Files, stuff like that, like all these investigative things. And what I want to say is, you guys were not wrong. You guys technically were wrong by the way the law worked. I actually worked for a lawyer in Jackson, Mississippi. So I know, shout out to Tony Baldwin. Y'all can ask him. I worked for Tony Baldwin, a whole lawyer in Jackson, Mississippi when I was staying in Pearl a couple years ago. So my understanding of the law, literally, I have a good background in it from a whole bunch of standpoints. I even dated a lawyer. Shout out to her. She actually went to Stanford. But, no, she went to McGeorge. I took that back. Anyways, Nash, what's going on? You're apologizing to us for you being right? Yeah, because you guys were essentially saying the act is wrong. The morality of it is wrong. If I see a bunch of officers that are lined up with guns and all this stuff, and I'm sitting down with 2 DAs and a judge in this freaking meeting, that's wrong. So that's where me, as the head visionary, should have been like, you guys aren't wrong, but y'all got to remember, we still black at the end of the day. Or y'all ain't got money like the rich whites do. We all average folks. We all average making people getting a regular dollar, so we don't get afforded the lawyers, the ability, the wealth that we get. We don't. We don't have that at our fingertips. Whether you black, white, Hispanic, Asian, whatever, if you ain't got money and you stepping into that courtroom, you are screwed. So I get it. And that's where my mess up was. Because I keep telling y'all, these lawyers have a brotherhood. They do. I was right in what I said about the ex parte meeting. Some of y'all still gonna disagree. Well, a judge that just booted his ass off could have said the ex parte meeting was wrong, but it wasn't. Brian still lied when he said that Kenneth Copeland was gonna admit that he murdered Donovan Thomas. He didn't do it. Why the hell would he do that? And the feds would have picked him up. But that's neither here nor there. Those lawyers, they got him. That was one of those, I'm gonna hit you with the right, bam. The moment that Glanville had an attorney start to represent him, and I understand how they meant it. The moment that you got a lawyer to essentially represent you, to fight your own case, to keep you on a goddamn case, bruh, you're wrong. You're in the wrong completely. Because the impartiality and unbiased part is they are not challenging you, the person, Glanville. They were challenging you, the individual, as far as the decisions you were making. The decisions by Glanville, not the man, but the court. And he got in his feelings about it. He did. They're on freaking Long Crime. They have a top 10 fiery moments with Glanville and all this stuff. And it looks bad because they had to recuse him. This does look bad for everybody involved. This has been the most eyeballs as far as an Atlanta case has went and has been in forever. So they had to do it for the sanctity of everybody. Now the biggest question then becomes the jurors. They're going to poll them jurors. We're going to have to get some new jurors, or they're going to have to basically declare mistrial, which more than likely is going to happen. Young Thug basically won this case because if they declare mistrial after they poll these people, the state ain't picking this shit up again. It's already done cost millions of dollars. They're not. Unless the pride of these individuals is so. I believe there's a mistrial that's about to happen. because of the jurors and basically the millions of dollars that they done already spent. They had to, because here's what propaganda will do. And some of y'all and a lot of y'all, maybe all of y'all will disagree. But please, before you disagree, hear me out. The premise of this whole entire thing was essentially saying that gangs are a problem in Atlanta, and we are taking down the gangs and the head of the gangs, a la a YFN Lucci, a la a Young Thug and YSL. Since they have been getting locked up, crime has went down. Go search the crime rates. That's the whole entire thing that they're going to run on. Fonnie Willis knows as well as everybody else does how to play politics. This is why she's always in the freaking churches. The Vox Populi outside of Atlanta, outside of Fulton County, believes that people do not like Fonnie Willis. Let me tell you emphatically, the individuals that vote, meaning that 45 and up crowd, it ain't the youngins. Those people, they love Fonnie Willis because on her watch, crime went down. And that's ultimately what they want. And the reason crime went down is because of that COVID disease. When we let everybody back outside and then everything started to calm back down. That's the reason why. But she ain't gonna tout it that way. She gonna say it's because I got all these people locked up. Now, if I pissed you off enough to make you unsubscribe, double back and subscribe again and be like, we good. Because at the end of the day, I appreciate y'all saying Seti Nash, you wrong, and articulating it. But I'm telling y'all, I do a whole lot of work behind the scenes, reading in the laws and all this stuff, the same way a first-year graduate would do. And I'm telling you, I knew from jump that what y'all thought was a morality thing, and I didn't articulate it because I was so hyper-focused on telling y'all I was right that I didn't even consider the emotional part. And that's just something I'm going to do and work on to grow this channel that we've been growing. It's all cool when we're giving away hundreds of dollars to the homeless and helping out people and all that stuff. But the reason why we're here is, one, to be educated and entertained. That's it. Subscribe, turn on that bell, stay notified, and share to keep your people aware. We got a major video coming up tomorrow, and I'll catch you on the next one.